Welcome to the Therapist Thrival Guide. My name is Miranda. I'm a licensed clinical social worker, and I'm here with Dr. Lucas Vellini, LMFT.
Hello. Good to be back in the studio.
Yeah, welcome. And we have a really fun topic today. We're talking about duty to warn, but specifically the Menendez brothers case, because it has brought up a lot of questions. So many questions that I brought my/Ellie's attorney on. Suzette, do you want to go ahead and introduce yourself?
Hi, Suzette Schommer. I'm Ellie's General Counsel and Chief Compliance Officer, and I've been with Ellie just under 2 years, and I'm happy to be here.
Welcome to the podcast.
Thank you.
And so Juris Doctorate, licensed attorney, but like branch of law, would you say you specialize in?
Healthcare. I've spent most of my career in basically every facet of healthcare, from government to payer to provider to PBM. And sort of that, I've done a lot of litigation management, but luckily not need to do much at Ellie.
Right.
Well, there you go. Yeah. So today we decided to talk about, we wanted a chance to talk about the Menendez brothers case because it is all over social media conversations, specifically the therapist, and wanting to talk about like kind of the crazy stuff that he did. And I think that naturally turns into a conversation about duty to warn, mandated reporting laws, confidentiality, all of that sort of stuff. And so let's dive in. Do we want to talk a little bit about like the case and say like, this is what our understanding is?
For those who haven't watched it.
I
just watched it last night. I had no idea that this entire case got... The breakthrough in the case was audio recordings from their therapy sessions, which is crazy. I had no idea.
Yeah.
And so I think it's relevant for clinicians to know also, so that was kind of the gist of it, right? Is they confessed the murder.
So the Menendez brothers,
therapist.
they murdered their parents and they confessed, they said
allegedly.
Yes. No, I think that they've admitted to it. They like even...
What is a confession?
Suzette, is now a good time for you to do your disclaimer?
Maybe.
Go right ahead.
So just like any, good or even, mediocre attorney, I have to give a disclaimer that anything I'm talking about today, it should not be received as providing legal advice to anyone at Ellie or anywhere else. I'm just talking more generally about my knowledge and experience on duty to warn in Minnesota.
Okay.
We don't give legal advice on this podcast.
Not on this podcast, but I'll stop doing it in my personal life.
So anyways, a big part of this case was that after the murders happened, the boys weren't even under the microscope. They weren't even the police weren't even looking at them. They just assumed these rich, young, good-looking guys had nothing to do with their parents' deaths.
They called the cops.
Yes.
They were the first to arrive at the scene.
Yep. So then one of the brothers had gotten in trouble with the law as a teenager, saw a therapist for a period of time, didn't see the therapist then for a long, long time. After the murders happened, he was feeling suicidal. He had classic PTSD symptoms. He was having nightmares, having just a lot of difficulty coping after he had just done this. So then he called up his old therapist, said, "Hey, can I come in and talk to you?" He ended up going in and talking to the therapist. They went for a walk, and on the walk, the brother said to the therapist, "We killed our parents." So then the therapist brought him back to the office and then recorded his confession. But I
don't know if he did it that day.
Okay,
so he called his brother, made his brother come in. Then the brother was there.
And the brother threatened the therapist.
Yeah.
Is what they are saying.
And what the therapist did do right away was before he called the brother to come in. So the other brother was already there. Calls the other brother to come in. As he was waiting for the other brother to get there, he calls his mistress.
Also a former client.
Who is also a former client.
Yes.
Yeah, the media is not kind to therapists. And he calls her and says...
I think the therapist did this to himself.
Oh, yeah. That's what I'm saying. They portray the worst of us. Because I guess that's what's most entertaining and dramatic. But I guess this is also based on real events. Yeah. And so these are the choices he made. Called her, said, "Hey, Eric, Eric just confessed to killing his parents. I need you to come to the office to be a witness. And so he immediately breaks confidentiality in that regard. Doesn't report it to law enforcement, but discloses it to somebody using identifying information. So she comes into the waiting room while the other brother gets there. They know there's a witness. And then from there, it gets interesting because they did threaten him. And so now he's in a position of my life isn't safe because they know that I'm the only one with this information. And yeah, so that's...
But then he didn't, but then things kind of played out years later. I think it was years later. He wasn't even with the mistress anymore. And then the mistress was who, I hate calling her the mistress, the girlfriend, whoever.
Yeah.
She then brought the information to the police and said, hey, this therapist knows and has these.
It was years later.
I think so.
Oh yeah.
Yeah.
I know the timeline.
It was a while later. And then it was, and then that was at the point when the law enforcement took the tapes from the therapist. And then there was a battle for a long time on whether or not this therapist could even, if these tapes were going to be admissible in court because of how they were taken and all of the kind of weirdness surrounding it. And then the therapist actually even ended up testifying in the initial court trial. And then, yeah, I mean, therapists, I think in general, are like shaking their heads and like, I couldn't finish watching the dramatized version of this because it was so hard to watch, but also I just hate watching things when therapists are really bad therapists. Like Shrinking, but
yeah, I will probably not be watching season 2 of Shrinking. So that was interesting to me. And are you familiar with this case, Suzette?
Well, fun fact, I didn't watch the miniseries, but the Menendez brothers are my contemporaries. This was going on when I was in high school and college, and so we knew all about it at the time. So, yeah, when, it's funny for the younger generation, this is their first exposure, and we sort of lived it day to day. It was all over, everything.
So were you familiar with kind of like all of the stuff happening with the therapists and the tapes and at the time?
No, not that. I mean, it was really, frankly, more of the like headline grabbing issues and really more focused on these rich, what was really portrayed as entitled, probably portrayed as evil boys who killed their parents for the money. I mean, that was the messaging I remember. And then I also remember the defense being a lot about the abuse, which it really hasn't been until more recently when I've sort of read headlines and articles that I delved into that piece more and understood it. But that was not the message of the day.
So where did this therapist go wrong?
Well, I'd say it's tricky to say he first went wrong by... I would say it's obvious to say, maybe I'd put it this way. It's obvious that him breaking confidentiality immediately by telling another woman who was non-clinical of what was happening. At the same time, it's like this guy was obviously very nervous and worried and scared. And he did that for purposes of his own safety. But that did open up, it's like once you step...
Maybe that's the importance of working in a group practice. So you can grab your colleagues and say, hey, I'm concerned about what's going on. I'm concerned for my own safety. Please stay in the building.
But also, I don't know if this was true for certain, but the way they portrayed it, Eric Menendez specifically asked to be the last client so that nobody else would see him.
That did happen.
And so there was an intention of not being seen by anybody else, about being alone with this other individual. And then so the first move was kind of bringing in that witness. His second move was interesting. And Suzette, I'd love to hear you weigh in on this because I really liked this. I thought this was a good move as a clinician, which is when he informed the brothers that he was like, I have evidence of these conversations stored away in a safety security box. And if anything were to happen to me, there are people who have been advised to check this safety security box, which would make it clear that you should be who the police are looking to as far as figuring out what my whereabouts or what may have happened to me. And so like he put in like this insurance policy for them to not murder him, which I thought was interesting.
Well, but he did it at, like, he recorded the sessions.
And then he said, if you want to keep working with me now, we're in this together. So I need to record these sessions. So like, it was like,
so they were aware that he was recording
at that point. Yeah.
Interesting.
But he kind of made it like an ultimatum. And he did use a lot of language of, again, like, we're in this together now. And so at this point, like, I was still willing to give the therapist the benefit of the doubt, despite that he broke the confidentiality by informing, another person. But with that insurance policy thing he did, like, it's certainly not best practices, to do anything like that. But it's like, you're worried, it's like this guy had legitimate concerns for his own safety. I would say where he totally lost me, and I was like, all right, this guy's just the worst, is when, well, one, his mistress, who was a former client, was also living with him and his wife and children.
I mean, shrinking again, former client living with the family. But
then when he essentially coerced them into investing in his small business.
The Menendez brothers?
Yeah. Like after one of the sessions, after he made
dual relationship.
So it's like, at that point, I was like, all right, this guy's the monster in this show. But as far as, well, I guess, and another big question too is, would you expect a judge to sign a search warrant to confiscate a therapist's recorded session tapes? Like, is that typical? Do you think that would happen right now today?
I think in something as extreme as a murder case, I think it could happen. And, that's the caveat to everything. I mean, as we know, confidentiality and HIPAA is just, tantamount to the client-therapist relationship. And it can always be overcome by a court order. And that's true on small matters or big matters. And I've had that happen. I mean, I've had a therapist be ordered to testify in a custody hearing that we try to oppose. And therapists, just like priests, have a similar issue, or other religious leaders. But some people will go to the mat, right? They will be happy to be hauled into, court or jail before they'll testify. That isn't required. And I think the key is really ensuring that all of that is contained up front in an informed consent. So that, the client may not be understanding, and nor would you, how this could play out down the road, but understanding that there are limits to confidentiality in more extreme circumstances. And, that's why nowadays we put such time and effort into the informed consent process, which I suspect was much less robust in the 1980s.
Yeah.
Well, so I guess there's, like what you were just talking about, there are a lot of different moments where it feels like he made some bad choices. But if you are a therapist that is working with, like, if you were in his position, and let's say you weren't sleeping with a former client, you were a good therapist, and you have somebody that comes in and says, you have Eric Menendez that says, I murdered my parents. What is your next move?
I'd call Suzette.
Yeah.
Well, but that's actually, like, I know you're kind of kidding.
No, I'm not.
But I was talking to our director of compliance, who, as you know, is also a therapist, about this as well, to get her feedback. And she talked about, honestly taking pauses where you need to consult with a supervisor, legal or compliance, that's probably better than winging it in a moment where you're feeling stress and anxiety, and just saying, hey, before we go forward on this, I want to make sure that I've got all my sort of ducks in a row as far as making sure you understand what this means from a conversation. So I think there is something to that, although it probably feels very awkward in the middle of a therapy session, I imagine.
Well, I mean, because what it comes down to, and I think why this issue is so gray, is that you are bound by confidentiality. I mean, you talk to any therapist and you'll say, what would you do if a client confessed murder to you? And any one of them would say, I would continue being there. Like, I wouldn't do anything. Like, you're not able to say or break that confidentiality in accepting cases like certain times. And so maybe that's part of the question that I want to ask you too, Suzette, is like at when is there a duty to warn? When is there a time where it is appropriate to be like, this is something that I'm mandated to report? Because theoretically, I mean, if somebody murdered, this is such a hard case, but it's like if you had a client who murdered someone and they told you, that person is not in risk of harm. Like you can't warn them. So there's no duty to warn there. If it's an adult that they murdered, then you're not mandated to report it to CPS. But I guess maybe that's one of my questions too. Yeah.
Yeah. Let's talk through that a little bit, and I'm only familiar with Minnesota laws. I mean, just so everyone's aware, every state has very different duty to warn laws. HIPAA applies to everyone, but the requirements about what you need to report and when is going to be very state specific. But generally in Minnesota, the duty, which makes it mandated and not discretionary, really only kicks in if there's a specific threat to a specific person. So even just saying like, I'm going to, blow people up is not sufficient. Mm-hmm. It needs to be like, I'm going to, kill my ex-wife because, I'm angry with her or whatever the case may be. Then the duty actually kicks in. Mm-hmm. The only sort of difference in Minnesota is there is a very recent law, I think it was last session, the extreme risk order law, that's very specific to handguns or, some sort of weapon, automatic weapon. And mental health professionals now have a duty in Minnesota to report specifically to the sheriff if someone has a weapon and is at risk of harming another person or themselves, where typically the duty to warn doesn't kick in for suicide in this case if there's a weapon involved. So, this Minnesota is just an example of how varying it can be. But I will say there is a discretionary part where you are protected as a professional, and it might not be the mandatory part in Minnesota where we have a specific threat. But you've got a client who keeps talking about they're going to go into a school. Mm-hmm. And setting aside the provision about weapons at this point and just looking at the duty to warn, you are protected if you in good faith report what you believe to be a threat to the appropriate authorities. Now, whether they follow up on it, that's within their own discretion. Typically, and again, I can only speak to Minnesota, but typically the law is pretty protective of professionals who are making good faith reports in order to protect general safety. And, as an attorney, that's where I err as well. I'm always going to err on safety. And what I always, tell my clients, who are all of you therapists, is, I'd much rather be in court defending our decision to report something for safety than defending why we didn't report something that ended up being, catastrophic.
So in Minnesota, can you explain duty to warn a little bit more? Like, if you have a client in front of you that says, I'm going to go kill my ex-wife, then you are required to notify the ex-wife as well as authorities?
Yeah. So it's really, and part of that is if you're able to, right? You may have no information on who ex-wife is. So there's different ways you can discharge, and it gets very specific about sort of discharge your duty, but reporting it to the appropriate authorities or the specific person if known or if able to, one or the other, both. It sort of depends on the circumstances, yes.
Sure. Now, what if you are working with a client who says that they murdered their girlfriend's child or something like that. How is that different than this case?
When the victim was a minor.
Yes, exactly.
So in Minnesota, that is different because there is a look back period for 3 different types of abuse, but certainly murder would fall into the abuse of minors. And if there's just one victim, it's a 3-year look back period. And if it's more than one victim, it's a 10-year look back period. So in this scenario, if the murder happened within 3 years and it's one victim, that would fall under the mandatory reporting.
Interesting.
Yeah. So, and again, that's something that's going to be super state specific.
But that's a mandated report, not a duty to warn.
Well, it's a mandated report. Yes, you're right. It's not a duty to warn. It's under the mandatory reporting that has to do with children, minors. Yep.
And that also applies to vulnerable adults.
It does apply, but the look back period doesn't apply to vulnerable adults in the same way.
I think that, I was talking to my family about this case and just about the fact that we were recording this, and they were having such a hard time. None of them are therapists. And they're having such a hard time understanding that therapists don't need to report a murder that happens, but that they need to report like a murder of a child that happens. And so they were asking me all of these super great questions of like, what happens if this person murdered a 17-year-old, so you'd have to report that. But if they murdered an 18-year-old, then you don't have to report that. And like, they were just coming up with all of these questions where it's like, yeah, this is a complicated part of all of this law. And I think that they were also having a hard time with the idea of like, if you murdered someone in the past, if you had a client that murdered someone, doesn't that mean that they will probably murder again? And I said, no, like it totally depends on the case and looking at patterns. And I think what you just said makes a lot of sense, where the look back is like, if the murder happened 20 years ago of a child, then you're saying that it, like in Minnesota, you wouldn't need to report because it would fall under like confidentiality stuff. And I think that would kind of argue that if they murdered someone 20 years ago, like they haven't done it since, there's less worry of, or less like risk of harm of that happening in the future too, right? But
like if they killed somebody and it's been 20 years and they haven't killed anybody.
Yeah.
And I'm sure the circumstances around it, like, was it a bar fight versus like this premeditated, I'm going to kill the neighbor who lives down there because I don't like the dog. Like, from a mental health standpoint, that feels very different.
Well, and I agreed completely. And I think that I was looking at like one of those therapist Facebook groups, and they were talking about, somebody had posed a question that was like, have you ever had a client confess murder to you? And there were so many therapists on there that said, yes, I have had a client confess murder, and nothing, like they're not able to say anything. And granted, I think a lot of the therapists that were like commenting on there would say, some of them had said like, well, I work in a prison, so it'd be crazy if nobody had confessed or something like that. And so those were maybe, I don't know, a little bit more understandable. But gosh, I think that the part that I struggle with a little bit about this whole conversation too, though, is like, what if it's somebody's family member who was murdered and they don't know who did it? And there's just like almost a moral part of some of this too, where you're like, I want them to have peace, but there's no risk of harm. There's no risk, like there's duty to warn does not apply in this. And so this is something I just have to hold on to forever.
And then it gets in, then you enter the territory of like, can I still effectively provide care to this person?
Yeah.
Which is, and within that too, it's like that notion of the therapist's sense of their own perceived safety, and being with this client.
Sure.
And also like, it's not just the therapist living with this truth, it's the person who committed the murder knowing that their therapist might be the only other person who knows this. And so in the world of crime, that's called a liability.
Yeah. Okay, you just made me think of one other question though for Suzette. So does HIPAA ever expire? Like at some point, like let's say client dies. Can I later say, Like I'm thinking of, like, what is that crazy serial killer that,
Ted Bundy.
Yeah. I'm thinking of, anyways, I was like, let's say you have your client is a serial killer from the 70s. It happened a long time ago. They murdered a bunch of people. They confessed to you. There's no risk of like, there's not a duty to warn in this scenario. The client dies. Like, at what point would you ever be able to say, I was the therapist of
the Zodiac
killer? That's who I was thinking of. Yeah.
There might be a therapist out there who knows who the Zodiac killer is.
Right.
HIPAA protects patient confidentiality for 50 years following their death. So basically the same standards apply. After 50 years, it's no longer considered protected health information. And so at that point, it has the same sort of status of any other non-protected information. But the interesting thing with the 50 years is, yes, that may be enough time for the decedent and close family members to sort of have moved on, but probably the therapist as well, right? So there's not likely to be any kind of first person accounting at that point. But of course, there's the notes.
Yeah. Well, let's hope that if the Zodiac killer confessed to his therapist, his or her therapist, that the therapist was only like 20 at the time. And so then maybe we'll get some information from that. But
let's not bank on this.
Yeah, no.
Some of the interesting things, I think to dig into with this is, Barker, when you were talking about your family and their response to this and like how this can trigger like your moral consciousness, of this isn't right, this is wrong. I think, well, correct me if I'm wrong, Suzette, but if a client discloses to you in session, it was after the fact, this murder already happened. If you were to go right to the police with that information, wouldn't that run the risk of like tainting the case and the prosecutor's ability to, take that person to trial? Because wouldn't that be inadmissible evidence?
It may, certainly the defendant's attorney would argue it's inadmissible. And, ultimately all that means is it's excluded. And so it shouldn't necessarily put them in a worse position. The prosecutor just doesn't put them in a better position.
But would that be enough for them to make an arrest if it's based purely on a solitary piece of evidence that they know is more than likely inadmissible?
Oh, yeah, that would be fruit of the poisonous tree, they call it. So if ultimately the fruit was tainted, then the whole tree is tainted. So from that regard, if they're relying on the therapist's information as the reason, ultimately it could, if they were relying on that to go to the house, to search the house, and in the house they found the weapon, that's where the sort of fruit of the poisonous tree. I will say this, though. Police officers have gotten very creative in knowing that's an issue and finding other ways. So they just survey the person and follow them as a suspect and then find some other reason to pull them over, find something in the car. Doesn't always work. But I did a police ride-along when I was in law school in Hennepin County, and they didn't even hide the fact that, they would follow people and they'd run their plates just to see if there was any like outstanding, parking ticket. And they'd use that as a reason to pull them over so that because they just figured they looked shady. I mean, this is again in the 90s. A lot hopefully has changed, but police are pretty good at working around that.
Okay, another question. So let's say you are really struggling with this morally. It's like a really big case. This is something that you feel like you're holding on to. You're not, like, you don't feel like it fits any of the rules. Thoughts about writing like an anonymous letter to the police or like giving an anonymous tip or something? Like, that was something that had come up. So I was curious.
I think people would be inclined to do that. I think that leads me right back to, like, would this be effective? Does that mean anything? Like, would that serve any good to law enforcement other than, giving them a reason to consider them as a suspect if they weren't already a suspect?
Well, like for the Menendez brothers. So let's say that the therapist did an anonymous tip or something. police found a reason to pull over Eric Menendez. And like Eric says in the documentary I watched, he had bullet casings from the murder in his car for a long time. Like even when they drove back to call the police, his car was parked in the driveway and there were bullet casings from the murder in his car.
Yep.
And so it's
the
like,
box.
And so, yeah, I don't know, like an anonymous tip to me feels like, okay, that could be one way around it. But I think my big question would be, Eric would know there's only one person that I've told. And so then.
And I will tell you from a legal standpoint, I would consider that a breach of confidentiality.
Okay, that was my question.
For sure.
Perfect.
Because you were taking information that was provided to you in a confidential session and disclosing it.
Yep.
So to me, it doesn't really matter how it's disclosed. It would be considered a breach. The part that you, the therapist, might feel better about is, oh, it's anonymous, so they can't trace it back to me. So although it's a breach, I'll never get caught. I wouldn't be so sure about that, right? Nowadays, the forensic capabilities are pretty sophisticated.
Nothing's anonymous.
Yeah. So to me, that would be an ethical decision someone makes, knowing that he or she may lose a license over it.
Which the Jerome Oziel did. He lost his license and
good.
He I think he voluntarily handed it to the board.
Yeah. He's like, I'm not going to fight this. It's pretty clear.
Yeah. Oh man. Okay, so what are the penalties for a therapist for breaking HIPAA? Do you know that?
Yeah, I mean, it's interesting because having always worked at organizations, we're really mostly focused on it as an organizational level. And typically, we report privacy breaches all the time in the sense of they happen all the time, right? That is, it's actually a bigger flag to the federal government if you're reporting nothing because it shows that you don't have measures in place. The email that went to the wrong address, the bill that contained an additional person's. I mean, this is just sort of standard. And then, of course, we all know about the big sort of data hacking breaches that happen. So from an organizational level, that tends to be a couple things, usually fines. And of course, the bigger the breach, the bigger the fine. And when I say bigger, it also means like, did you have policies and procedures in place to prevent it? So as the chief compliance officer, that's what I'm always focused on is, we understand that human error is going to happen all the time, but do we have a system in place that to the extent we can, we're protecting against that? So it tends to be financial and then sort of in what we call injunctive, where, okay, now you have to do X, Y, and Z to shore up your systems. So if you take that in an organizational level, and it's just a smaller scale on an individual level, and of course, you all have your own licensing boards, and probably that's to some extent the biggest concern about any sort of breach on that level or report to a licensing board about, sending an anonymous letter about a client and whether that is an issue that the licensing board would take up. Probably an individual, the fine isn't going to be $200 million like it might be for United Healthcare. But fines, injunctive relief, and licensing issues are the three things I'd be thinking of as an individual.
And there is like a component of like, was this out of pure negligence or was this truly a slip? Like the notion of the HIPAA slip. Like if it was something that wasn't done out of negligence and you caught it, I think even it's similar to like a criminal situation, the more like there's a process for you to be forthcoming, to acknowledge that I made a HIPAA slip, seek, the guidance, even if it's directly from HIPAA. They have a lot of policies and procedures of how, like if there's like an email breach, this is what you need to do to respond to
mitigate it. Yeah.
And so like if you take responsibility for that end of it, I would say you minimize the risk of harsher penalties than if you try to hide it and you get reported by a client, or like if it gets brought out to awareness in some other manner, because now you're also dealing with the fact that you did something, that you shouldn't have done and you tried to hide it as opposed to just take accountability for it. And so with a lot of the reason I say that too is like like you said, we're going to make mistakes. Like humans are organized around error. And we shouldn't be looking to our regulatory boards and HIPAA as like an adversary, as like a punitive authority, that's against us. It's when you're acting in good faith and you're making good choices and you mess up, it's like those institutions, you can see them as a resource. Like that's what I would see them as a resource. And how can I go about rectifying this, and correcting for it? But of course, there's always going to be a component of once that is brought to awareness, it's out of your hands as far as how they decide to proceed, and what actions they take moving forward. And so, consulting is always important. There's clinical consulting. There's also legal consulting. If you have malpractice insurance, typically your policy will be able to identify an attorney that they can connect you with. They want you to be using your policy for those purposes. So the resources are out there. And so don't ever feel like you're alone in this stuff. Like Dr. Oziel, he seemed to just be flying solo.
With his former client, though.
His former client, girlfriend.
That he was sleeping with.
Which is stunning.
Is that where we...
I don't know if that's that. What, I think maybe what would be helpful for people to know is maybe we could spend just acknowledge, like what exactly can you do in these situations? Because it can be a lot for you to hold, especially if it's your first encounter with it. And when do you know that you're not going to be able to continue to provide quality care for this client in light of what you now know, and what's the most ethical way to manage that process? Do you know, Barker?
Well, I mean, if I had somebody who confessed murder to me, I think that I would call Suzette.
Yeah.
And I would say, hey, let's talk through this. Like, what's my duty here? Like, do I have any duties to report? But I think that I would also be just really mindful of, like, depending on the circumstances, that could be heavy to carry. And so absolutely be talking to like your supervisor or colleagues about this. But I think that also kind of gets a little bit sticky of like, how much consulting can you do with colleagues in this case? Maybe that's another question for you. I mean, because I would want to call you and be like, hey, can we talk through this a little bit? Like I'm struggling, but I think that I just want to be very clear of like, how much would I even be able to tell him?
Yeah. Because now I'm going to be like, great, there's a murderer in the office next to me Tuesdays at 1 p.m.
Yeah. Well, HIPAA does protect within an organization consultation, supervision, et cetera. But also, one thing to keep in mind is that the minimum necessary standard always applies. And so I do think in this type of situation, again, unless there was some sort of risk factor, but if it was more, hey, I want to consult with Lucas on this client, you wouldn't be sharing their name or frankly, which hour they're in. You would just be talking about the circumstances around it. And that would be completely appropriate under HIPAA. But the more information you give, right, the more risk that something's going to be disclosed, especially if Lucas is now like, shoot, I have my kids here at 3:00 and, et cetera.
What else do you think you would do, or what would you want to keep in mind, Lucas?
I mean, there are just so many particulars here. Like when you said you were surprised by the number of therapists who have had clients who have disclosed this. Like a good follow-up question to that data set would be, like, what was the recency, of the murder relative to the disclosure? Like, I think the Menendez case was very rare in the sense that, well, not only, was it confessed, relatively soon after it happened, but this had the attention of the entire country. Like, it was a story that everybody was talking about. And so that's a very unique situation that adds, varying degrees of complexity there. But I would say more times than not, these are things that have happened, in the past. It's not, the body's not in the trunk in the parking lot, I guess is what I'm saying. Like, that would be a very uncommon situation. But yeah, I mean, I think it's not all that different than, any other situation in which clients disclose things to us that might challenge our personal sensitivities, cultural beliefs, sense of comfort, and being able to provide quality care. And, at the end of the day, it's like the client who just confessed a murder to you is just as deserving of quality clinical care as any other client, on your caseload. And, kind of in the big picture, I can appreciate how people in the public can think it's crazy that we would have knowledge that there's a murderer and that we're not just turning them in. But at the end of the day, if clients didn't know that they had that right to confidentiality, they wouldn't be disclosing these things to their therapist. It's like when I explain informed consent to clients, it's not, if they're like really curious about it, it's not uncommon for me to use murder as the example.
Yeah.
It's like if you murdered somebody on the way here, I can't say anything about it. If you tell me you're going to murder somebody as soon as you leave here and I know who that person is, I have to say something about it. Because that is kind of the most obvious black and white way to explain the limits of confidentiality in that regard. But it's like, would we rather have people who are living with the fact that they murdered somebody, be talking about this clinically or keeping it to themselves? Like from the perspective of, is this a good law? I would say that's what argues the fact that it's critical that these disclosures are protected by confidentiality, or else it's just more information that people are suppressing. And as clinicians, we know better than any other discipline what happens when people suppress something as significant as an experience like that. So be ready for it, be prepared for it. In general, it's like the longer you practice, the less anything surprises you, I would say.
Sure. Yeah.
And when it comes to duty to warn too, like it's, Suzette, and again, check your state statutes. But it doesn't necessarily require like law enforcement intervention. It really is just making sure that the potential victim is notified and aware of this threat existing.
If you can.
And so like the craziest story I've ever heard that that kind of falls into the context of what we're talking about today is when my mentor was working with a client who showed up to his office one day and said she just wanted to stop here to let him know that she's on her way to go shoot her husband at his office. And she pulled out the gun that she was going to use, and she was just holding it. And so, I mean, the way he managed the situation was just started asking her a lot of questions. One, it's like he said it was like a 6-shooter. It's like, have you shot?
Thank goodness he was at the office that day.
Yeah. He's like, have you shot that before? And she's like, no. He was like, well, how far is his desk from like where you walk in? It's like, these are not accurate. It's like, how confident are you that you're actually going to be able to hit him? And she didn't really think about that. But then he really gets into, he was like, don't you think it would be a bit unjust for him to not even know why you're shooting him? Because she found something out about him that he didn't know she found out. And so she was just going to go kill him. And he was like, well, that kind of lets him off the hook, wouldn't you say? And she was like, yeah, you're right. And he's like, well, how about this? How about we call your husband right now and you let him know why you're coming to shoot him at his office? Because I think it would be important for him to know. And she ultimately agreed to calling him. And so they put him on speaker and she said, I'm coming to the office to shoot you. And this is why, yada, yada, yada. Which checked his box of the duty to warn. Would you agree?
Yes,
so
in
you
Minnesota.
warned the potential victim, and he ended up doing couples therapy with them.
Oh my gosh.
Weeks later. Yeah, this guy's crazy. He's my mentor, which would make sense.
Wow.
So that's a pretty remarkable.
What does your case note look like after that?
Oh, well, that was back. What did case notes in general look like in the late 80s, early 90s?
Actually, wait,
Post-its?
let me pause you there. If I have a client that confesses murdered, should I document it in case notes?
Oh,
then?
yeah, that's a good point.
So definitely what I would advise people is not in your progress notes, which are the notes that can be disclosed in a court of law. This is something that, I think one of the options is psychotherapy notes, which I think there's, not necessarily a complete and thorough understanding on how those are used, but those are protected from a court of law. They're not part of the record, and they're a therapist's own personal notes. So a lot of times a therapist might use them to put levels of detail that they want to remember. It's less maybe about documenting, but like they want to make sure that they have their sort of record of this personally, and it's not part of it. Now, just like anything else, there's always a chance, court would order those. But that would be where you would put the most sensitive information that doesn't belong in the record.
Mm-hmm.
Yeah. Yeah. And with that,
that's where you'd put your video or your audio recordings too, or I'm just kidding. That was Suzette's like, absolutely not. That's where this therapist might have done that, but
yeah, everything's detectable. Anything in writing that passes through a phone screen or a computer screen can be, they can find it.
Yeah.
And it's almost impossible to like truly keep anything totally hidden from the record. In every capacity, especially with the power of a court order. But yeah, I mean, that's one of the most misunderstood aspects of HIPAA is that psychotherapy notes are for the professional. They're not considered part of the medical file. And so when clients ask for your psychotherapy notes, it's like you can be clear that it's like these aren't for you. Like this isn't not your property. As
we should probably do a training on that.
Yeah,
because it isn't understood broadly. It must not be trained on in most, disciplines.
Mm-hmm.
And so at a different organization, and this is when everything was paper, this was before electronic health records, I had people keep them in a green folder so that there was never a mistaken sort of disclosure when it came to providing records.
Yeah.
Well, this was such a good conversation. Like thank you so much for answering all of my questions on this, Suzette. It was so helpful to kind of just pick your brain on all of these crazy circumstances, gray areas, and just honestly helpful to learn a little bit more about what falls under these different laws. I think this has been really, really helpful.
Oh, yeah. Yeah, hearing directly from an attorney in almost any situation, like they kind of quickly can cut through the ambiguity that can be cut through. So yeah, that was just super helpful to get a much more clear sense of what we need to be mindful of as we navigate these waters of murder and therapy.
Well, awesome. I hope this episode was helpful for you all, and we'll see you next week. Welcome to the Therapist Thrival Guide. My name is Miranda Barker. I'm a licensed clinical social worker.